Hello, this is Nestle Benoit. I'm with TransFlorida Schools, and today we are doing real estate practice questions. We're going to focus on titles, deed, and ownership restriction questions. Question 1. A property owner has an easement pertinent on her property. When the property is sold to another party, the easement. Let's read the question again. A property owner has an easement pertinent on her property. When the property is sold to another party, the easement A becomes a lien on the property, B terminates, C transfers with the owner to a new property, D transfers with the property. The answer is D. An easement pertinent is an easement that benefits one parcel of land, known as a dominant tenement, to the detriment of another parcel of land, known as a servant tenement. Easement pertinent are attached to the land and are transferred automatically when the servant or dominant tenement is sold to a new owner. A, B, and C are incorrect. It does not become a lien, it does not terminate, and it does not transfer with the owner. A property owner can avert the danger of losing title by adverse possession by, again, a property owner can avert the danger of losing title by adverse possession by A. Claiming hostile and notorious possession, B. Filing a claim of right with the county recorder, C. Recording proof of ownership in county title records, or D. Inspecting the property and evicting any trespassers found. The answer is D. A person through adverse possession may acquire legal ownership based on continuous possession or use of a property without the permission of its legal owner. A is incorrect because hostile and notorious possession gives constructive notice to the public and legal owner that a party other than the owner is occupying and claiming to own the property. B is incorrect because claim of right is an action taken by the possessor who maintains the property as if he or she was the legal owner. C is incorrect because recording ownership does not alone protect the owner against adverse possession. However, to avoid losing title by adverse possession, an owner should periodically inspect and evict any trespassers found. If a person dies with no legal heirs or relations and has left no valid will, what happens to real property owned by that person? Again, if a person dies with no legal heirs or relations and has left no valid will, what happens to real property owned by that person? Answer A. It is reconveyed to the previous owner in the chain of title. B. It is conveyed to the highest bidder at a public auction. C. It is taken by the title insurance company according to the process called involuntary alienation. D. It is taken by the state according to the process called a cheat. Answer D is correct. A cheat is a common law doctrine that transfers the real property of a person who has died without heir or will to the state. Answers A, B, and C just do not make any sense. Choice A is incorrect because it does not go back to the previous owner. B is incorrect because it is not automatically auctioned. And C is incorrect because the title insurance company has no claim on real property even after death. To be marketable, title must be, again, to be marketable, title must be A. free of undisclosed defects and encumbrances. B. Registered in Torrin. C. Guaranteed by a title certificate. Or D. Abstracted by an attorney. Answer A is correct. A marketable title is free of undisclosed defects and encumbrances. A marketable title is one that can be transferred to a new owner without the likelihood that claims will be made on it by another party. Choices A and B and C can be used to establish ownership, however, does not guarantee clear title against defects, unrecorded encumbrances, and encroachments. The torrent is not applicable in Florida. Which of the following summarizes the general terms of a ground lease? Which of the following summarizes the general terms of a ground lease? A. A tenant buys the landlord's ground, then leases the improvements. B. The landlord leases the ground floor of the building to a commercial tenant. C. The landlord sells the ground to another, then leases it back. Or D. The tenant leases the ground from the landlord and owns the improvements. Answer is D. The tenant leases the ground or land from the landlord and owns the improvements. For example, a farmer may lease land for the purpose of agriculture. The farmer owns what he or she produces. A court renders a judgment which authorizes a lien to be placed against the defendant's house, car, and personal belongings. This is an example of a court renders a judgment which authorizes a lien to be placed against the defendant's house, car, and personal belongings. This is an example of a voluntary judgment lien, B. A general judgment lien, C. Specific judgment lien, or D. Superior judgment lien. Answer is B. General judgment lien. A property owner may create a voluntary lien to borrow money or some other asset secured by a mortgage. A specific lien attaches a single item of real or personal property and does not affect other properties owned by the debtor. The category of superior or senior lien ranks above the category of inferior or junior liens, meaning that superior liens receive first payment from the proceeds of a foreclosure. What is chain of title? What is chain of title? A. The bundle of rights linked to the recorded title to a parcel. B. The list of all parties who have ever owned real estate. C. Involuntary conveyance of title by statutory rule of descent. D. A chronology of successive owners of record of a parcel of real estate. The answer is D. A chronology of successive owners of record of a parcel of real estate. If there is a missing link in the chronology of owners, or if there was a defective conveyance, the chain is said to be broken, resulting in clouded title to the property. A hermit secretly lives in a cave on a 200-acre property. After 20 years, the person makes a claim of ownership to the property. This claim will likely be: a hermit secretly lives in a cave on a 200-acre property. After 20 years, a person makes a claim of ownership to the property. The claim will likely be: A. Upheld through adverse possession. B. Declined because possession was secretive. C. Declined through the doctrine of prior appropriation. D. Upheld because of the length of possession. The answer is B. Declined because possession was secretive. In Florida, a claim may be made after 7 years. However, must have notorious possession, which is possession without concealment. A brick fence straddled the property line of two neighbors. The neighbors agree not to damage it in any way. This is an example of: a brick fence straddles the property line of two neighbors. The neighbors agree not to damage it in any way. This is an example of: A deed restriction, B, a trade fixture, C, an encroachment, or D, a party wall. The answer is D, a party wall. A person wishes to convey any and all interest in a property to another without making any assurance as to encumbrances, liens, or any other title defects on the property. This party would most likely use which of the following types of deed? Again, a person wishes to convey any and all interest in a property to another without making any assurance as to encumbrances, liens, or any other title defects on the property. This party would most likely use which type of the following deed? A special warranty deed, B, a partition deed, C, a sheriff deed, or D, a quiet claim deed. The answer is D, a quiet claim deed. A special warranty deed, the grantor warrants only against title defects or encumbrances not noted on the deed that may have occurred during the grantor's period of ownership. The deed does not protect the grantee against claims that predate the owner's period of ownership. Sheriff deed, used to convey foreclosed property sold at a public auction. Partition deed, used to convey co-owned property in compliance with the court order resulting from a partition suit. What distinguishes a lien from other types of encumbrance? What distinguishes a lien from other types of encumbrance? A, it lowers the value of a property. B, it is created voluntarily by the property owner. C, it attaches to the property rather than to the owner of the property. D, it involves a monetary claim against the value of a property. The answer is D. A lien is a legal notice that attaches to your property title because of an unpaid debt. It gives the unpaid party a legal claim to a portion of your property when it is sold, and you typically can't sell or refinance your property if the lien isn't cleared.